Hello everyone to my presentation on insolvency. I will speak today on this topic briefly explaining definition of insolvency, ways to insolvent a company, partnership and individual, receivership, liquidation and principal methods of dissolving a company will be discussed. I will take brief overview of the Insolvency Act 1986 of England and Wales and talk about the problems with cross-border insolvency. Definition of insolvency. Insolvency is the situation of companies when they either do not have sufficient assets to pay debts, or in other words, their liabilities are more than assets are unable to pay debts as they become due and payable. Insolvency is a prerequisite of bankruptcy. Under the Insolvency Act 1986 of England and Wales, there are various ways to insolvent a company. Number one, administration. This is a temporary delay of action called moratorium to allow a company to restructure. This needs to be initiated by a court order. This can be done promptly and has the benefit of staying the actions of creditors. Number two, compulsory voluntary arrangement, CVA. CVA is a voluntary arrangement between a company and its creditors under the supervision of an insolvency practitioner. This is cost effective and simple to arrange than an administration. The negative aspect is that there is no stay on the actions of creditors during the CVA process. Receivership. The appointment of a receiver, generally an insolvency practitioner, by a creditor or by the holder, for instance a bank, of a floating change over the company's assets called administrative receiver to collect the assets and realize those assets and repay the debts. Liquidation. Winding up a company voluntarily or through the courts wherever the assets are collected and realized, debts paid, balances distributed. Dissolution. This is a situation of breaking up and disposal of a company. Options for partnership under Insolvency Act 1986. Partnership administration is a temporary delay of action which is called moratorium by creditors to allow a partnership to restructure. Partnership voluntary arrangement, PWA and like CWA. Winding up liquidation of a partnership through which the assets are collected and realized, debts paid and balances distributed. Options for an individual. Individual voluntary arrangement like CVA and PVA. Bankruptcy of an individual by court order. Receivership and liquidation. Receivership in England and Wales related to companies refers to administrative receivership. The administrative receiver is appointed by a secured creditor. The receiver may also be appointed by the court order under some situations. The administrative receiver has to be an authorized insolvency practitioner. Such authorization should be by the Department of Trade and Industry, but the actual process of authorization is carried out by the Institute of Chartered Accountants, the Association of Certified Accountants, the Law Society or the Insolvency Practitioners Association. Section 1 of the Insolvency Act 1986 gives the administrative receiver power to take possession of property, raise money, appoint professional consultants, and carry out business of the company as the company would had it not been in receivership. Liquidation principle methods of dissolving a company. Members or shareholders voluntary liquidation (MVL), whereby the members or shareholders appoint an insolvency practitioner to oversee the dissolution of the company. Payments to creditors, including employees and tax authorities, and repayment of shareholders' capital. This is used where it is expected that all creditors will be paid in full. This is commonly used in restructuring companies where a subsidiary is no longer needed or feasible. Creditors in voluntary liquidation (CVL), where the members and/or creditors pass a resolution that the company cannot continue. Trade in or pay its debts. They generally appoint an insolvency practitioner to act as liquidator. If the members and the creditors each appoint separate liquidators, the creditors' liquidator will have precedence. Compulsory liquidation. If it is impossible for a company to pay debts and has no option other than liquidation, then an application is submitted to the court by a creditor or the or by Secretary of State of England and of UK. The court will appoint the official receiver in the status of a liquidator. The official receiver will realize the company's assets, appoint an insolvency practitioner as the liquidator, who will realize the assets, dispose of them, and distribute payments to creditors. Insolvency Act 1986. Insolvency Act of 1896 of England and Wales states that creditors can be secured fixed charge as a bank, mortgage company, finance house, etc. Reservation of title. That is, creditors can reclaim assets which have not been paid for, where full payment was a condition of transference of title. Debts subject to lien. That is, the right to retain possession of assets until settlement of debt. Preferential unsecured debts, for example, pay, weight, customs and excise, inland revenues, etc. Non-preferential unsecured, that is, ordinary creditors not falling into any of the above categories. Distribution of funds. The distribution of funds after realizing the assets and disposal will be handled in strict procedure. Fixed charge holders will be paid first, followed by preferential creditors, floating charge holders, and then remainder of the creditors, that is, unsecured creditors. Shareholders will be the last to receive anything. The common law approach is considered to be very pro-creditor concerning insolvency. France is considered the least pro-creditor, followed by the US. In England and Wales, there is no stay on assets. Secured creditors are paid first and management is kept away from the reorganizational process. The US corporate law permits stay on assets and there is no restriction to initiate process of reorganization, allowing the board of management to remain in control during reorganization. France law is similar to the US, however, does not allow secured creditors to be paid first. Germany is close to England and Wales in its pro-creditor approach. However, it does not distance management from the organizational process. Problem with cross-border insolvency. Problems arise when the debtor and the creditor are from different jurisdictions. For liquidation, the corporate domicile of the company will be ascertained, and the court of the country of corporate domicile will act as the principal court to govern the liquidation. In England, the principle in cross-border insolvency is that the law of the place where the liquidation is opened, lex fori, will govern all matters relating to the winding up, including the avoidance of preferences and other transactions. The courts in England and Wales recognize the ancillary status of a domestic winding up order if a foreign company is also subject to a more significant liquidation in a foreign jurisdiction. The courts in England and Wales regard the country of incorporation as the principal forum for controlling the winding up of a foreign company. And where that company has assets in England and Wales, ancillary winding up procedures should be initiated according to bankruptcy procedures while working in harmony with the foreign courts. Thank you.